Good evening to everyone, and thanks for joining us. Here is the book. You can find it on the Amazon, of course. Thank you, everybody, for your time. I'm excited to share with you the third of our four presentations tonight. No real housekeeping on my end, other than that you're welcome to type in questions as we're moving along. Jeffrey is always so good about bringing those to my attention. Jeffrey, if it's okay with you, I will share my screen at this time.
Okay, go
Let's see.
ahead.
Okay, here we go. Let's see. All right, looking good. I do a little jot to get back to the beginning. So hopefully that looks good for everybody. Okay, let's see. So as always, I love to show off the Oregon City elevator. So on the left, 55 years ago, and on the right, as we sit, and our office is fortunate to be right behind the elevator. I thought I'd go over the agenda, kind of what we have done for the last few meetings. So we talked about why we have the playbook. We talked about how to assemble the playbook. And we did kind of an overview of what's inside the playbook. In the very first session, we dealt with goals and objectives, and kind of the executive summary there is if it ain't writ, it ain't. So be sure to write down your goals. You'll have a much better chance of accomplishing them. The thing we did last week, which was, as I understand, kind of a dense topic for a lot of people, which is really, creating your own net worth statement and your cash flow statement or your balance sheet in dealing with all that stuff that comes in the mail. This can be kind of a tedious act and one that we don't want to deal with, but really it helps us reduce clutter, get rid of statements that we don't need, create one consolidated sheet with everything on it to help those that take over for us eventually. So that was last week. This week is going to be really fun. And I'm excited because we're going to talk about not only what goes inside of the legal documents and estate planning section of your playbook or your preparation, but rather than just tell you the things that go inside, we're going to take a little journey into defining what those things are and why we need them, why we don't need them, and some tricks and some mistakes that we see things to avoid. So we'll spend a lot of time kind of just talking about the context of what estate planning is, and some time talking about what goes into the playbook side of the playbook or of the estate planning. And then next week, which will be our final section, we're going to deal with insurance, what you need to keep, what you need to consider, along with Social Security and pensions, which are more relevant for people of latter years than coming years. But if you have one, you're lucky. But we'll talk about unique strategies with Social Security and solvency issues and when to file. And then, of course, what always keeps our tax advisors happy is how to organize our tax stuff in our playbook to put a smile on their face on tax day. So let's dive into today's topic, which is estate planning and legal documents. And I wanted to frame this conversation by talking about three strategies that we see people use when it comes to estate planning. The first one, which is the successful strategy, and I'll give an example of a client who came in to see us and they said, "Hey, I have a very specific goal. I want to make sure that my assets avoid probate. I want to make sure that my kids have assets left over. I want to make sure that I have bequests going out to certain charities. I want to make sure that I'm protected in my life." They were very clear about what they wanted. We put together a plan. They took action and they were successful by following some simple steps, and they used the playbook. But there is really just the notion of attacking that goal and making sure that you accomplish it. That's the proactive way to deal with it. Another way to deal with it, and if we look at this cute picture of this little kid with his hands over his eyes, and he's looking away and he's ignoring something. That's another thing that we see often. And I think of an example where we've got a very, very successful client who owned a business, manufacturing business, and the client would work a lot and spend a lot of time on the business, but just ignored the estate planning side because they were just really focused on the business. And eventually, this client, probably from work, had passed away a little too early for our taste. And the kids who also worked in the business said, "Okay, well, we need to transition the estate." And because it was ignored, the estate was probated and complicated, and it took a long time. And we heard the figure tens of thousands of dollars spent on attorneys to help resolve a lot of issues. And I think even a few of the siblings aren't talking to each other because things just weren't dealt with. So that strategy does not seem to be a good one. So we have a successful strategy, which is let's deal with it. The strategy of let's ignore it, and then finally the procrastinator strategy, which I would identify with for the things that I'm not successful at. I tend to procrastinate. I know it's important. I know I should do it, but I just keep putting it off. And an example of that is I had a friend come to me recently, not a client, but a friend. He said, "Ben, I know what you do, and my father's going in for surgery, and he's in his 80s, and can you give me the executive summary of the quick things I need to do to fix his situation just in case?" And we started going down the list, and it was overwhelming because there is no real quick fix. It's a process that we got to figure out. And fortunately, the father got out of the hospital just fine, and had followed up with a friend saying, "Hey, do you want to readdress this?" And he said, "We'll do it later, next time, maybe next week, we'll have coffee." So let's be successful, let's be proactive, and let's get a plan together. Okay, so let's jump into kind of a big picture topic, and I'm excited to talk about this because sometimes it turns light bulbs on with people, and I can see it, and it's exciting. And while our mind is fresh, I want to make one thing very clear. There are two types of assets in this world when we die. Those that are probated, in other words, they go through the court process, and those that are non-probated. And most people don't like to have probated assets because it's expensive. It takes time. It's a matter of public record, and maybe we don't want it to be a public record. So probate isn't generally considered favorable. So I want everybody to know that things that are covered by your will are going to be probated. So a will is simply a document that helps guide the probate process. So if you didn't have anything that was subject to probate, your will wouldn't do a whole lot for you. So to be clear, a will governs the probate process. Everything covered in your will be subject to probate, and things that are not covered or not specified at all will be probated. So that's one side of the world. The other side, the other extreme is non-probated assets. So these are things that are owned by a trust.
Question.
And so, yeah, thank you.
Yeah, so Susan is asking, aren't trusts more expensive?
In general, yeah, I would say, getting a trust set up is more costly than getting a will set up initially, like the initial cost. Um, there are various other ways to deal with avoiding probate, though, and let's circle back to that. I would
Okay.
say that yeah, trusts are a little bit more complicated, a little bit more complex, but they do a whole lot more. Um, so other things or other ways to avoid probate are having beneficiaries on accounts. And some accounts are naturally set up to avoid probate, like an insurance policy where it has beneficiaries, or a retirement account like a Roth or a 401k where you name beneficiaries. These things automatically avoid probate because the financial institution knows where you want them to go, and it is obligated to send them that direction when you pass away. So
Mhm. And a
another option
question
is,
about
yeah,
from Terry about the probate process. What
yeah.
is the probate process? If there are specific things mentioned in the will, how does that affect the probate process?
Um, maybe a specific example, like for example, if and I'm reaching here, but if your will says, I want the house to go to, this child, for example. Well, you've expressed that wish in the will, but in order for the title of the house to get transferred to the child, you would need a court order, and that is the probate process. So, in other words, the title company or the isn't just going to turn over the title to somebody because you give them a will. They're going to wait for the court to give you letters of testamentary that says, yes, this does in fact go to them. So that's kind of the process of probate. And let me know if that didn't answer your question.
She said, if you say in your will, I want the house to go to X person, why would that be probated? And then the estate pays for the probate process?
Yeah. So I'll give another example, and this is the same with a house, but consider a bank account. Let's say that you have a bank account at US Bank, and you say, when I die, I want that bank account to go to my son, John. So you pass away. John has a copy of the will, and John goes to the bank with the will, and he says, here I am. I'm John. Here's the will. Give me the account. The bank is going to look at John and say, we don't know who you are. We don't know that this will is valid. We don't know that another John didn't already come up and give us the same will and take the money. So, in order for the bank to relieve themselves of the liability, they're going to wait for a court order in order to give that account to John or house or anything mentioned in the will. So that process in waiting for that court order is the probate process. And so as a financial institution, my broker dealer is not going to just turn over an account to anybody because we're liable for it. We could give it to the wrong people, and we don't want that liability. And so the way for us to draw a line in the sand and say we don't want the liability of giving it to the wrong person is to have a court tell us that, hey, this is the right person to give it to. And that's the probate process. So again, anything covered in a will is just guiding the probate process. And that probate process is going to require a court order for us to transfer those assets. And that's why we get frustrated, because it shouldn't be that hard. It ought to just be like, well, I want my assets to go to so-and-so, and at death they should go to so-and-so. But what I'm describing there is a non-probate asset. And you can do that several ways. One is by having assets owned by a trust. Another is having a beneficiary named on the asset. Or you can have a transfer on death or payable on death designation on that asset. So I think our first question was, well, aren't trusts expensive? And yeah, they are expensive. You could spend thousands of dollars on a trust in order to avoid probate. But good news, it's not the only way to avoid probate. There are several other ways to avoid probate. And all we really want to do is have beneficiary designations on all of our accounts and all the things that we own, and we would naturally avoid probate. So, I'll hit it one more time. Like if I have a retirement account and it's got beneficiary designations on it, and I pass away, the financial institution that has that account knows exactly who to give it to, and they are not liable for giving it to the wrong person because I told them. I filled out the beneficiary form, so they know who to give it to. So there's no liability. But if somebody comes up and I didn't have beneficiaries and they just gave me a piece of paper, a will, and said, hey, I get these assets, I would have liability if I gave it to the wrong person. So I'm going to wait for those probate court orders in order to give it away. So, so really what we want to do, I think an effective estate plan for a lot of us is avoid probate. And if we're going to avoid probate, we really don't need a will because a will governs the probate process. So what I'm going to do is I'm going to go to the non-probate side of the world and say, okay, I can do this by putting the name of stuff in a trust, which might be expensive. Or I can just make sure that every account that I have has some sort of beneficiary, like an insurance account or retirement account. Or if it's a non-qualified bank account or savings account or stock account, I'm going to add a transfer on death designation or payable on death designation to it, which is simply naming beneficiaries. Or maybe I own it in a manner like joint tenants with rights of survivorship. Like I own it with somebody, and if I die, they get my share. So, by the way, and Jeff, you and I talked about this early on. The transfer on death designation is available in most states right now for real estate. So, if you own a house, a piece of property, you can add that TOD designation, and so at your demise, it will transfer directly to your named beneficiaries, thus avoiding probate. So,
Oh, a whole dialogue going here in the chat right now. Terry said yes, helpful, thank you. But then she asked who pays for the court order. So that's one question. I got three things here.
yeah. Okay. I'll
So you
tackle
wanna,
that. Yes. So the estate is going to pay for the court order. So, in other words, if I pass away and I've got $1,000 and it cost me $900 to go through probate, my estate is going to be reduced down to $100. So, it is the responsibility of the estate to pay for the probate process or court order.
okay. And then Susan said in her experience that the probate process costs less than setting up the trust. She said if one has a significant amount of money, then a trust may be a better option. That's what her lawyer recommended. And then Terry said, oh, did you want to comment on her comment?
Sure. Yeah, I suppose you would find it. That is a scenario that is possible. Absolutely. And it depends on the price of the trust and if you use a trust. I mean, there's certainly ways to avoid probate entirely without using a trust. So that might be the first option. I call it I call it the prudent person trust is the use of transfer on death and payable on death. It's a prudent person trust. I figure that's what Warren Buffett would do. Who still eats at McDonald's. He would use the prudent person trust. It's free. It doesn't cost any money. So if free isn't too much of a price to pay, and then you avoid the cost of probate entirely and the wait and the time that it takes for probate, it's a matter of choice. But you're right. Sometimes the cost of the planning that we do, the trusts that are set up, can outweigh the benefit of them. And I would I would say that I have seen several instances where people will come in to our office and they have had this elaborate trust created by an attorney, a good meaning attorney that cost them thousands and thousands of dollars to create the trust when they didn't need it, when their goals would have been accomplished in a much better way through the use of maybe a transfer on death or payable on death. So yeah, it's a great point, and I thank you for bringing it up.
Okay. And then Terry asked something and then someone commented on it. So I'll read both of those. So Terry asked, so a mortgage could have a transfer on death? Question mark. I am sure you will cover this, but what will there be but what will be there tax liability for a mortgage that is TOD? And then Denise said, wait for the answer on that question, as a mortgage is a debt that will have to be satisfied by the disposition of estate assets to the debt holder. It's not really an asset per se. And then Susan said, if all the financial assets have named beneficiaries, there may not be sufficient money to pay for estate expenses.
Wow, what a dialogue. I love it. I feel like there's some legal knowledge going on in that back and forth, which I think there's definitely truth. I think in the answer is that one, if you pass away with a house that has a TOD on it, the title goes to your TOD recipient. The mortgage that exists is still a lien on that property. So the mortgage doesn't get transferred to a TOD. You wouldn't transfer a mortgage to somebody, but it's still a lien on that property and against that property, which will have to get satisfied. So we don't spend a lot of time worrying about transferring on death of mortgages. We just want to transfer the asset, and then we have to deal with the fact that it had a mortgage when we get the asset. So that kind of resolves itself.
Yeah, and Marcy said she's a New York attorney and she's never heard of transfers on death or payable upon death in New York. And I think I could say that we don't have it for property. We don't have it for real estate, but we have it for financial assets. And Terry,
Come on,
thank
New
you.
York. Come on.
And then Susan said one has to file a person's last tax return. There may be credit card bills, etc. And thank you, Pepita, for your comment. If you have any questions, we can also answer yours as well.
One interesting notion to consider is that while you may die broke, or while you may even die owing money, your money debt that exceeds your assets doesn't get passed on to your estate. That is the risk that a lender takes. So while you may inherit a mortgage, you've also inherited property that exceeds the value of that mortgage. Is kind of the presumption. So, great
Okay, and
questions.
then
Great dialogue.
more dialogue from Marcy. Is a bank going to allow a transfer of the asset it has a lien on? And Bruce said that New York has TODs and PODs on financial accounts. And someone else who I won't name said, well, why not get on with the seminar? And Susan said the IRS isn't a lender.
Good point. And so, even though a mortgage company may have a lien on a property, the title of the property is held at a county record, and so it's not up to the lender who is on the title. It is up to the county. That's a little loose, but when somebody dies and they have a TOD, the title transfers to the TOD recipients. The lenders can squawk about it all they want, but they can't get in the way of that transfer. Okay. Great dialogue. Thank you for the questions. We can circle back to that too. I want to cover titles and registrations, just a short list and why they matter. And I think this is before we get into what should go in your playbook or what you should set aside and how you should organize stuff. Just again, as kind of general knowledge. So there are several different ways that you can own accounts. You can own them singly, so all by your lonesome. Like for example, I can have a checking account that is just Ben James saving account. When I die, that registration would be subject to probate. So in order for my wife to get it, for example, she would have to get that court order to transfer it to her because it's just owned by me. Another way to own an account is to own it in a trust. So if you've paid the money to have a trust established, which, by the way, I don't know that trusts are something that you shouldn't consider. I know they cost money, but they can do a whole lot of interesting stuff. And so there's a value there. There's certainly a cost, but there's certainly a value. So if you have a trust set up, the account can be owned by the trust, but controlled by the trustee. And so I have the James Family Trust that owns the bank account, but I control the account because I'm the trustee. Now, when I pass away as the trustee, the trust still owns the account. So there's no probate. It's not subject to probate because the trust still owns it and the trust didn't die. But now my successor trustee steps in and controls the assets. So that's a trust. Another thing, which we've already talked about, is the POD, which is payable on death, or transfer on death designation. I use them kind of synonymously. They do slightly different things, but if you've got that designation on an account, so for example, I could have the Ben James account POD to Marky James. When I die, the assets would be payable on death to Marky. It would avoid probate. I like the idea of avoiding probate. There are custodial accounts or for benefit of accounts like UGMA accounts, uniform gift to minor, or custodial accounts. That's the case where somebody's in charge, but it's owned by another person. So for example, my kids might have UGMA accounts. Now I'm in charge. I'm the person in charge of the account, but my kids own them because I gifted money to them. Lucky kids. So in this case, if I pass away, there's a successor person in charge, but my kids are still alive, so there's no probate. So if I passed away, it doesn't matter. There's no probate because my kids are still alive. Next, there's joint accounts. So I can own an account in a joint tenant capacity or a joint tenants with rights of survivorship. So this is a difference. So when you go to the bank and you set up an account with somebody, you want to clarify, is it joint tenant in common or is it joint tenants with rights of survivorship? And here's the difference. If it's joint tenant in common, we own it mutually, right? But at death of one, his or her share goes to their estate. So for example, I have a business partner and we own a bank account together, or we own a piece of property together. When I pass away, I want my share to go to my family. I don't want it to go to my business partner. So that's a joint tenant in common. If I own an account with my wife, I would want to use a joint tenants with rights of survivorship, which is the second option. So we own it mutually, but at death of one, the remaining owner gets it all. That works great for my wife because I want her to get it anyway. I don't necessarily want to have a joint tenants in common or JTTEN with my wife because then she wouldn't necessarily get my share right away at my death. Eventually it would get to her through probate. And I wouldn't want to have a joint tenants with rights of survivor with my business partner because I don't want stuff to transfer to him. So titles and registrations are really important. When we talked about financial statements, I said, when you're creating your net worth statement, it's so helpful when you list out all of your accounts to have that exact registration listed on your net worth statement because they matter. They matter how things are probated or if they're probated. They matter who controls things. They matter successor control. All those things are really important, which is why we save one copy of every statement of a financial institution that we do business with, because we want to have proof of what that registration is so we can double check. I'll say that one more time. Save one copy of every statement of every financial institution that you do business with. So one copy of your IRA account, one copy of your bank account, so we can see what those registrations are. Okay, attorney, do I need one? So this comes up quite a bit. So let's talk about the pros and the cons. First, attorneys are a deeper level of understanding, without a doubt. And because of that, they're good counsel. Attorneys are going to get us to ask the questions that we don't even know exist. They see things from an educated perspective that allows us to get a better service and a better result. I think most people will benefit from an attorney, if not all. I also find that having an attorney or an established relationship with an attorney is really useful, because when you need to rely on that relationship, it's there for you. And that's probably one of the best things about networking with professionals, is when your time of crisis is here and you've already got an existing relationship with that attorney or that counsel or the tax advisor. They're there for you. You're not going to be going through a screening process. The downside to attorneys, the big one, and it already came up, is, man, it's expensive. Those law degrees are expensive, and so the attorneys have to charge money to pay for that law degree, and it's not free. It costs us money. Where sometimes we think we can download stuff off of LegalZoom, and we can, but if we get it from the attorney, it costs money. The thing about
Question.
attorneys, yeah.
Yep. Jumping back to the previous slide, Susan asks, since you're giving joint ownership of funds to your wife and or kids when you're alive, do they owe taxes on the money on it, since they are entitled to the money while you were living?
Well, it's a great question, and one that it's complex in thus that there is unlimited transfers between spouses with no tax implications whatsoever. And so, generally speaking, if it's just a bank account and I pass away, that account's going to go to my wife, no problem. My kids, however, depending on how much money is in there, if I'm subject to estate taxes, my kids may have to pay estate taxes on it. So it depends on the size of the account. Now, currently, estate tax thresholds in Oregon are pretty low, but nationally they're very high. So they may pay estate taxes, but my wife would not. Um, on the other hand, if it's an IRA account, which wouldn't be a joint tenants with rights of survivorship, but if it's an IRA account, um, it would have some tax implications to whoever gets it. If it's a low basis stock, for example, it would get a step up in basis at death, and then my kids would essentially inherit it tax free, but not estate tax free. So complicated question. I would say generally, most of the time, if it's my family, they're going to get it tax free. And I hope that answered your question.
And
So,
she wrote, there would be no taxes if they inherited via will. And she said, yes, it answered the question.
oh, good. Yep. Yeah. The tax side doesn't really matter whether it's probated through the will or whether it's non-probated through a trust or TOD. The tax implications are always the same. I think no matter what you do for estate planning, the IRS wants to get theirs as much as they can. So there's only so many loopholes, and there are some that exist, like an AB trust and a few things that'll help minimize estate taxes. But for the most part, like if you've got an IRA account and you pass it on to somebody else, that eventually the IRS is going to get their taxes. Yeah. Last thing on attorneys, and I want to be careful saying this because it's just one perspective, but to some degree, attorneys are transactional in that often they'll create an estate plan, they will they will bill for it, but there's not necessarily an ongoing process in place to make sure that estate plan is followed. And so what I tell people about attorneys is that it's not their responsibility to call you up every year and make sure that you're sticking to your estate plan. Although it's certainly in their best interest, and a lot of them have that practice. But if you think about creating an estate plan with an attorney, it can be transactional. It's really up to the person buying the estate plan to make sure that they're following it, and hopefully you're working with people that are making sure that you're aware of what you need to do. So I would say in general, yeah, get an attorney.
And Faggy is saying that in New York State that banks freeze accounts if the owner dies, even if there are beneficiaries. She has learned this is common practice because heirs, beneficiaries, etc., tend to litigate. Therefore, you need co-owners on each account, not just beneficiaries. And Susan said, I've been an executor a number of times and the bank did not freeze any accounts. So I guess it depends where you live. And
Yeah, interesting. That's an interesting perspective. And I, not having experienced probate or a dissolution of an estate in New York, I couldn't speak to that necessarily. But certainly in the number of states that we've worked with, it's been very clear when you have beneficiaries, the accounts go to the beneficiaries. And again, I think a lot of that stems from, as a financial institution, the biggest fear we have is giving assets to the wrong person, but we can't wait to give them away because they are a liability for us until we've gifted them away. So when we've got beneficiaries, we've got clear instructions from the owner of the account before they died. We're good. We're going to pass those accounts on. Yeah, it's only in the case where it's subject to the will or probate that we are going to have to wait for that court order. So interesting. I appreciate all the back and forth on the chat too. It's like a self-answering question, so very nice. Okay, so now we'll kind of dive into what's inside the playbook, and I just have a few things that I think we all know your will, your trust, your power of attorney, healthcare power of attorney, legal documents go here. I could leave it at that, but we're going to add some more color. I'm going to tell you some of the favorite things that I put inside my playbook and our client's playbook. So the first thing we do is we do a beneficiary review form. So this is so important to get right. um, we see beneficiary designations wrong often when we're doing beneficiary reviews for people. And I'll tell you what happens. So, for example, we'll have a client come in, they started a 401k 10 years ago. They've since, either lost one of the beneficiaries or divorced, but they failed to update their beneficiary designation. If that client were to pass away without updating their beneficiary designation, the financial institution, again, is going to give the money to whoever that beneficiary is. Now, that may be battled in court with mixed results, but the first instinct of the financial institution and then the rules they have to follow is to give it to who the beneficiary are. So what we do is we have a process of going through and double checking every account to make sure that the beneficiaries are correct. And we feel like that ought to be done, every couple of years, just to double check until we know for sure that they're all right. This is a system you want to make sure that is in place, so there's no doubt in your mind you don't have the wrong beneficiary designation. I'll also mention that I'll introduce some more terminology, which is pro rata or per capita, and just talk real briefly about what that means. So when you have a beneficiary, you can designate pro rata or per capita. And here's what it means. I have 3 sons, and if I designated all of my kids as contingent beneficiaries in a pro rata manner, it would mean that if one of my kids passed away and I only had 2, that the kid who passed away, his share would go to his brothers. Three boys, by the way. So I'd essentially have, 2 contingent beneficiaries. That's pro rata. So that is effective for me because I've got minor kids. That works good. Now, when they grow up and my kids have kids and I'm a grandpa, if that happens, maybe if one of my kids passes away, I would want his share to go to his kids. And that is called a per capita designation. So in that case, if one of my kids passed away before me and then I passed away, but I only had the 2 beneficiaries remaining that were still alive, the child's share who passed away would then go to his kids rather than to the other surviving kids. Sorry for all the finger gesturing there, but hopefully that makes sense. Pro rata, per capita, it matters. We have found, and it's very interesting, that financial institutions love to default stuff to pro rata. So be careful, because if you want it to be per capita, you almost need to go out of your way to specify. And I think shamelessly, what we like to do is go pro rata because it would be really easy because we don't have to worry about tracking extra beneficiaries down. So double check that pro rata or per capita. One other thing that we find helpful in our practice, and I think we have an attorney on the call here, so I'll be careful saying this, but man, sometimes attorneys get paid by the page. And so a will or a trust where, we would like to think that it can be expressed in a few words. By the time we get through all the legalese, it's a 30 or 40-page document or a long document potentially. And so, and for good reason, because it's complex. But I think for the benefit of the layperson, and I've read, hundreds might be an exaggeration of trust or wills, but I don't want to read them more than once. And so typically what we'll do is we'll create a summary page and we'll stick that right on top of the will or the trust. So, it might be, in section 1.1, we've got the financial representatives. In section 1.2, we've got the trustee, just kind of like a highlight, special provisions, who the beneficiaries are, any concerns that I might have about the trust. And why that's helpful is when I'm questioning, oh man, what does our trust say? What does our will say? It's right there. So sometimes wills or trust will come with a summary page. Sometimes we need to make them ourselves. But having that kind of that index or quick reference guide to what could be a long document is helpful for us. And we put it inside of our playbook. So what do we do with our will or trust? Obviously, we want to keep a copy of your trust or your will inside your playbook. I happen to keep my original, and then I've got digital copies backed up. The will or the trust document should immediately follow your summary page. That just makes sense. Some people are most comfortable keeping the originals in a safe or deposit box. Again, I keep my originals inside of my playbook, and I'm quite comfortable doing that. Um, so power of attorneys, that's another thing to keep inside your playbook. A copy belongs in your playbook. So what are POAs? So everybody knows powers of attorney, and what do they do for us? Well, so I have a 401k. I've been a diligent saver all my life. Now, that 401k has a beneficiary designation. In the event that I pass away, it goes to my wife, then my kids. But if I'm in a coma, or I'm out of the country, I'm indisposed, I can't be reached, and my wife, who essentially is co-equal owner of our entire estate with me, but not on my 401k because I own the 401k, because only one person can own a 401k. So if I'm indisposed, but I'm not dead, how does she access my 401k if she needs to? So that is the reason that we have a power of attorney. So if Marky needs to access funds that are only in my name, she uses the power of attorney that we filled out and is in our playbook in order to do so. So it could be that, I'm not dead, but I'm in a coma. She's got a POA to access funds that she might need to pay bills. She might need to make some allocation changes. Who knows? So while I think about the will or the trust kind of protects the process of passing on assets to our loved ones, amongst other things, it's the power of attorney that protects us during our life and protects our estate during our lives. So, the good news about a power of attorney is they're a much less complex document than a will or a trust. So they're easy to obtain. They're cheaper to get. There are several different types of power of attorneys, and I won't dive into it, but there's durable and springing, and there are some cautions to be taken. But for most of our clients, we recommend a power of attorney as part of their estate plan. Um, Additional fun TODs. So, by the way, this is a TOD, or transfer on death document. Pretty easy. I remember the first time that I filled these out for properties and brought them up to the county, and I was surprised at how easy the process was. I handed them over, they stamped them, they took a copy, they gave me the stamped copies back. I put them in my playbook, and voila, I was done. We've had a number of clients who've passed away with transfer on death on their real estate or other assets, and it seamlessly just transfers to their beneficiaries. So at least in Oregon and most of the states that I've dealt with, all the states that I've dealt with, it's been a seamless process. So I like to think that transfer on deaths or payable on deaths or beneficiary designations are really what every financial institution should be doing anyway, and what they would want to do, because it relieves them of the liability of giving it to the wrong person, so they don't have to wait for a court order. And so probate isn't necessary, and they can get it off their books and into the hands of the people that it belongs to. So, by the way, the difference between T.O.D, or transfer on death, and P.O.D, which is payable on death, is that, well, an asset like a property isn't something you would necessarily want to liquidate. So it would transfer to a beneficiary, where a bank account, savings account, checking, something that's completely liquid, it's just a money in an account, that can be payable or paid out on death. So we use the terms interchangeably, but typically you'd find transfer on death for investment accounts or property, and payable on death for checking accounts or savings accounts. POD, TOD, and more fun. I recently had a run-in with a neighbor at a vacation property. I know this never happens, but there was discussion about the ability to cross over a driveway and whether an easement existed or not. And it reminded me of how important it is to, when you have easements on your property, or easements that you can use on other property, documenting those easements, because although we like to think that we're neighborly and those things aren't going to come up, it is a legal document. And so I store copies of easements in my playbook for easy access. That's why when issues come up, it'll be right there at my fingertips. Other things that we might store in our playbook: advanced directives, legal contracts, promissory notes, anything legal related. So promissory notes might be I loan one of my kids money, and which happens all the time. And I'm going to document that and store that promissory note in my playbook, along with my net worth statement and my balance sheet. So more things that might go in your estate and legal section: estate planning, will or trust, power of attorneys, healthcare power of attorneys, advanced directives. One we haven't talked about yet are burial arrangements. This is a big one. If you've taken the time and you have specific wishes, putting it in the estate planning section makes a lot of sense. Last wishes, kind of to add to that, here's some things that I want to happen at my demise, my last wishes. Legal contracts, sometimes these can be employment contracts. They can be easements. So anything legally related. So we called it estate planning and legal documents for a reason. We're going to keep our legal documents here as well as estate planning documents. So a Schedule A, the Schedule A. I'll talk about that a little bit. The Schedule A is something that is referred to in many trusts that I've read. It'll say, the disposition of assets, or, refer to Schedule A. And then you go to the very back of the trust and there's this blank page and it says the Schedule A at the top, which means that we didn't take the time to fill out the Schedule A. Well, a Schedule A is simply a list of assets that aren't necessarily going to pass by title or registration. So not an IRA, but it could be that China set from, great grandma, or the grand piano, or art, or a gun collection, or the jewelry in the safe. So a Schedule A is going to refer to all those things that grow legs and walk away at death. So if we document those things in the Schedule A and put that inside our playbook, that'll give our beneficiaries or our heirs a pretty good chance of understanding what our wishes were. So, for example, if I pass away, I might have a Mad magazine collection that, my brother and I shared growing up. And even though I got the Mad magazines because he moved out of the house first, if I pass away, I want to make sure those Mad magazines get back into his hands. So I'm going to put that in my Schedule A. That's not suggested reading, by the way. Finally, I find it helpful to put love letters, and I've done this every year or two. I'll update my playbook and I'll stick a new love letter in, for a loved one. So at the time that I passed, they would open up that love letter and have, something else to laugh at. Okay, so we're doing good. We've got a few more minutes, so I'm going to talk about 7 items that are frequent mistakes that we see made all the time, and I hope none of you make them. The first one is adding kids to your bank accounts. So we worry about probate, and so sometimes the instinct is, I'll just add my kid to my account. Don't do that. Here's the problem. Let's say that you add your kid to the account, and it's a small account. It's $5,000, but you want him to have access, or her to have access. But then you sell your house. Well, real estate's expensive now. Your house is $1 million. You sell it. You plop that $1 million into your bank account. Well, guess what? You just technically gifted your child half of that, $500,000. You get to file a gift tax return. And worse than that is your kid goes out and he's riding her or his motorcycle and runs into a physician. The physician finds out that, hey, they have assets and they sue your child. Well, guess what? They're now going to go after his or her share of your bank account. So we don't want to do that. Don't add your kids to your accounts. It makes them, liable for the gift, and it also makes them or your estate subject to their potential heirs. So better to have them listed as a payable on death recipient or a signer, but not to have ownership. Second mistake is assuming the will has got it covered. We used to hear this all the time. I'd say, well, hey, who's going to inherit your 401k? Let's do your beneficiary designations. And people would say, oh, don't worry about that. My will's got it covered. Just to be clear, just to double check, Your will is not going to dictate what happens to your 401k. Your will is only going to govern the probated process. Your 401k is going to be designated by what beneficiaries you have down. So it's going to go to your beneficiaries. So don't assume that your will's got it covered. Don't assume that the will covers stuff for you. Opening up new accounts, forgetting the updates. Let's say you go to the expense of getting your estate plan dialed in. Your goal is to avoid probate. Maybe you buy a trust, but then 5 years later, you open up a new account and you just open it up as a joint tenant in common. We see this all the time. People pay for a trust, but then they forget to use the trust. Not updating beneficiaries. That's the case where maybe you've got a beneficiary that has passed away and you forget to update it. Worst case scenario, and we've seen this happen, is one spouse divorces another spouse, doesn't update the beneficiary designation, spouse passes away, ex-spouse gets the assets. That's frustrating. Maybe you've got the wrong registration for your goals. We see that often where, somebody has a joint tenants with rights to survivorship, even though they have no intention of leaving assets to the joint owner. Finally, no payable or no POA on file. We think that's a big mistake because that's that legal form that protects us during life. So get a POA. Last one, and this is always fun to share because I've seen this happen multiple times, is there's a tendency for people to put one beneficiary down, the responsible child, and assume that that child is going to dole it out to its siblings. Well, that child may, because it is responsible, but what happens is that child then inherits an IRA account, which is all taxable to them. They pay the taxes on it at their tax rate, which is elevated because they got all of it. And then they pass on assets to their siblings, which then becomes a taxable gift. So make sure that your beneficiary designations are who you want it to be to go to completely. So with that, I think I'm 3 minutes shy of 5 o'clock. So
Oh, great.
thank you.
Well, thank you. Thanks so much. We still have some questions. Eleanor earlier asked, what about trust versus TOD in terms of how much work, time, hassle it is for the executor and or heirs? If one is much easier than the other, it might be worth the extra cost.
In my experience, I have not found any difference in terms of the work required by the executive estate of a TOD versus a trust. The assets transfer in terms of the TOD, and they remain in the trust eventually to be transferred to the trust beneficiaries. So probably the same amount of work. Where I think the real value proposition of a trust is, in my experience, isn't the probate avoidance, but it is it's dictating what happens to the funds in the trust in specific manners. So, for example, I might have a kid that I'm like, there's no way this kid is going to get more than $1 at my demise because he's going to blow it on whatever gaming technology there is. God forbid he gets 100,000. So what I need him to do is to get it over a 10-year period of time systematically. And I think that's where a trust for me really shines, is it can really pinpoint in what my goals and objectives are.
And Susan wrote that her uncle forgot to include his car in his trust. Since it was pretty old, all that was needed was to file a form at the DMV and pay $50.
I have a really funny story about this. At one point I went to the DMV and I got this old beat up 914 who my brother used to help me work on it, and I wanted to add a TOD to my car, and in Oregon the DMV said you can't do that in Oregon, and I said, well, then how do I get, do I need a trust? And they said, no, we can't even put it in a trust. And I said, well, then how do I get it for my brother? And they said, well, your brother just simply comes to us and says, hey, my brother died and he wanted me to have this car. And he signs an affidavit swearing that it's his. And I think it was 3 or 6 months later, they would just give it to him. So I said to the DMV person, I said, hey, there's a Ferrari outside. They didn't think it was very funny. And that would be fraud, but that's a loophole in the system.